Welcome back. This is Sharon Vornholt, and today in video 2, I'm going to talk about starting the probate process and how this process all takes place. Now, remember in video 1, we talked about the event, which is when someone passes away. So there's a lot going on during that time period. There's a lot of delays, and there's a lot of emotion before they can move on to step 2, which is when they actually file the probate, when they open the probate. So how this all happens is someone goes to the court to open the estate. In my part of the country, they'll refer to that typically as the next of kin. So now what happens next will depend on whether or not there was a will found to be part of the estate. So when someone goes to court to open the estate, if there is a will, that's called testate. That is an estate that's testate. So there is a will, but this will must be proven. It has to be determined that this is the last will and testament, that somebody hasn't slid in one that was maybe an earlier version or whatever, but that's the court's job. That's not your job as a probate investor. Now, once they have determined that it is a valid will, the court will give you something called letters of testamentary, a letter of testamentary. And that's a document that is granted by the court that says you have the right to, take care of this estate. Now, if there was a will, in the will, someone was named the executor. So when I made my will, and certainly if you made a will, you know this, you name the person that you want to administer your estate. This is the person that you trust with your money, with your belongings, and you trust them to carry out your wishes. So that is in the case of a will. That person is called an executor. Now, what if there is no executor? What if the person died without a will? Well, it's the same process. It is called intestate, and the court will issue what is called letters of administration. So this is a document granted by the local court that gives a particular person the authority to administer the will. Now, it's important to point out that there's no difference here between the powers of an executor or an administrator. The duties and the responsibilities and the whole legal, the way this is supposed to be carried out legally is exactly the same. It just means that the deceased did not personally choose this person. So once the person has the letters, they can take those to the bank or to the credit card company or whatever business it is that they need to take care of with this estate. They have proof. This is the proof that they are the person that is in charge of this estate. Now remember, you always want to be working with the decision maker. The decision maker is the administrator or the executors. So once they have this paper, then they can go about the business of settling the estate. And in the upcoming videos, I'm going to go through the rest of the steps, each step by step. I'm going to keep this short and simple. And remember that at the end of this, I'm going to give you an opportunity to grab a copy of the graphic that details the entire process. So hang in here with me in this series of short videos. I think you're going to learn a lot. And let me know if you have any questions. You can leave them over on the Louisville Gals Real Estate blog, or you can email me at sharon@sharonvornholt.com. And I'll be back tomorrow with another quick video. Thanks so much.